My first topic is compliance with the Employment Standards Act. The ESA is the statute that sets out the minimum protections for employees in Ontario. It's quite a technical act, and there are exceptions throughout the act. So what I'm going to be giving you are some of the general rules. The Act does not apply to federally regulated employers. I don't have a list of the attendees this afternoon, but if you are federally regulated, you are governed by the Canada Labour Code, although some of the minimum requirements and protections are the same. The ESA is enforced by the Ministry of Labour through its Employment Standards Program. Investigators in that program have a broad range of hours, which include being able to enter and inspect a place of business without warrant to investigate a possible contravention of the Act. The ESA is also enforced by complaints. Employees making complaints. It's quite an easy thing to do for employees. It's very cheap. It's really a matter of a telephone call to the Ministry of Labour, and then a complaint is filed, an investigation is done, and an order is made. And then in terms of violations, they are remedied by way of orders, fines, and in extreme cases, prosecutions under the Provincial Offences Act. So as stated, the ESA will govern all kinds of aspects of the relationship, including payment of wages, accruing, tracking, and paying vacation pay, hours of work, record keeping. To keep things somewhat short today, I've chosen hours of work, public holidays, and leaves of absences, which the last one, leaves of absences, is, in my opinion, the largest source of litigation or problems between employers and employees, and I'll get into that one in a little bit more detail. Hours of work. There are your hours of work. The maximum required hours of work are 8 per day, 48 in a week. You can exceed those hours if there's an agreement. However, the agreements must have certain formal requirements, so you probably want to speak to the Ministry of Labour. Probably best case to speak to an employment lawyer, because when you're contacting the Ministry of Labour, you're usually getting someone on the phone and they're doing their best to provide legal advice, but at times they can be wrong. In other cases, you need to seek approval from the director of the Employment Standards Program to enter into an agreement for hours of work beyond the maximum required hours. Your eating periods are set out there, at least 30 minutes at intervals not less than 5 consecutive hours apart. Minimum periods free from work, 11 hours in a day, or 24 consecutive hours in every work week, or 48 consecutive hours in every period of two consecutive weeks or more. The overtime pay is something that sometimes clients will unintentionally get wrong. Employees are to be paid 1.5 hours for every hour of work in excess of 44 in a week. You can't enter into averaging agreements, so if you're expecting a real rush on business or a real demand on your labor for, say, a week, you could enter into agreements with your employees to average those overtime hours out over a 2, 3, 4-week period, which will reduce your liability for overtime pay. In the alternative, if you don't want to pay the 1.5 hours of work per overtime hour work, you can give the employee 1.5 hours paid time off in lieu of every overtime hour work. Your public holidays are there under the ESA. I believe they slightly differ under the federal sector. And how public holidays work are, if the public holiday falls on a work day, you give the employee a day off with public holiday pay, which is an average of their wages over the previous 4 weeks. The employee is not entitled to public holiday pay if the employee fails without reasonable cause to work all of the last day of work before the public holiday, or the first day of work after the public holiday. If agreed, the employee can work and earn regular wages on the public holiday and take a different day off of work with public holiday pay. Oh, do we have a question here? All right. Hang on, we're just trying to work this out so we could read your question.
48 hours a week, when do we start to pay overtime? 44 hours a week, right?
Yeah, so every, I guess technically every minute above 44 hours is overtime. So that's paid 1.5 times the regular rate. If that answers your question.
And I think the reference to 48 hours a week, that's the maximum hours of work a week. Without approval by the ministry, you're not allowed to allow your employees to work more than 48 hours.
That's right. Back to the public holidays. If the holiday falls on a day that is not a working day for the employee, meaning a day the employee would normally have off or a vacation day, you have two options. One, the employee remains off and you substitute a different day. So you add, most cases you add a day at the end of the holiday and pay the employee public holiday pay for that day. Or if for some reason you need the employee to work on the day and the employee agrees to work, you can substitute a different day off with public holiday pay, or you can pay the employee public holiday pay and premium pay, which is 1.5 times for every hour worked on the public holiday. So you have your two options there, if that makes sense. Yeah, that's fine. We'll go ahead. Leaves of absences. This by far causes the most confusion and problems in the employment relationship that I see regarding all the possible sources of concern under the Employment Standards Act. Employees are entitled to a maternity leave. Under the Act, is specifically referred to as pregnancy leave and parental leave. The employee becomes eligible for these leaves after 13 weeks of service, and the combined entitlement is 52 weeks. There are other leaves of absence that I'm not going to get into, but in some cases there's family medical leave, organ donor leave, personal emergency leave, reservist leave. Some of these entitlements do have preconditions. For example, personal emergency leave, I believe, requires that the employer employ at least 50 employees. But the principles and the legal obligations are all the same. So your obligations during an employee's leave of absence: no, you're not required to pay the employee wages. Some employers offer top-ups. That's purely a negotiated benefit that's between the employer and the employee, but if there's no agreement to pay wages, you don't have to pay those wages. The employee continues to participate in most types of benefit plans unless there's an election not to do so in writing. And your typical comprehensive health care benefits will remain in place. Your medical, your prescription, your dental, vision, all of that. There's nothing in those policies preventing coverage to continue during the leave of absence. So the employer will continue to make its contributions to the benefit plans. Many of the employers make at least a contribution to part of the premiums, if not all. However, if the employee gives the employer a written notice that he or she does not intend to pay his or her portion of the premiums, then you do not have to offer those benefits during the leave period. Okay, so the most important part of the leave of absence, or the most important benefit is upon return, or upon the end of the leave, the employer is obligated to reinstate the employee to the position the employee most recently held with the employer if it still exists, or to a comparable position if it does not. Again, Typically, these cases happen where an employer, say you're dealing with an employee that's been working for you for some time, perhaps there's a sense of entitlement, the luster in the relationship is gone, the employee leaves on a maternity leave, and during the course of the year you hire someone who's younger, more enthusiastic, cheaper, and perhaps even during the year you realize how much better the office environment is without the employee who is on that leave present. And then you often see employers who are reluctant to reinstate the employee on maternity leave. My advice is to not get yourself caught up into that situation. It's pretty obvious what is happening. And the employer, if the employer makes a complaint, which I'll get to the possible remedies, the employer has a burden of proving that the decision to dismiss the employee or not reinstate the employee had nothing to do with the decision to the employee's decision to take mat leave. This is extremely difficult due to the timing of the decision, due to the fact that the employee has been out of the workplace for a year. Really anything short of a significant reorganization and elimination of several positions and proof that in the normal course the employee would have lost her employment because perhaps the employee on that leave is junior to the other employees is going to fall short of the burden of proof, and the employer is going to be liable to the employee for some significant compensation. So this is where it is. I take you to now. The consequences of breach of the leave of absence provisions. So what normally happens is the employee can, on his or her own, file a complaint with the Ministry of Labor or have retain a lawyer. And a complaint is filed probably within about 3 months. A fact-finding meeting occurs, and then shortly after that, the Employment Standards Officer will make a decision. The remedies, the typical remedies sought are reinstatement, which most clients really do not want given what has transpired. The employer is going to lose a lot of face. If the employee returns to the workplace, there's going to be stress and tension in the relationship. In addition to reinstatement, there's damages for the full loss of wages and benefits during the period of unemployment. And if reinstatement is not allowed, then the Ministry of Labor will award damages for the loss of the value of the job, and those are typically a month per year of service, and these are not subject to any type of mitigation. And then there's also compensation for pain and suffering, which are usually anywhere between $1,000 and $2,000. So a typical case would be an employee who is has 8 years service, is not reinstated, fired, and the employer trumps up some sort of performance problems that were revealed during the course of the leave period. Then, and say in 5 months, a complaint is filed, fact-finding meeting is held, and a decision is made, and the decision is contravention of the Act, and no reinstatement, which is commonly the case because the relationship is so fractured by that point. So the employee would be entitled to that case approximately 5 months of wages, assuming the employee is still unemployed, 5 months of lost wages and benefits, and approximately 8 months of damages for loss of value of the job. So you're looking at 13 months paid. And the employee could find work the day after the decision is rendered, and he or she would be entitled to the full 8 months pay for the loss of value of the job.